Welcome to the annual Law Library of Congress Constitution Day lecture. My name is Aslihan Bulut, and I have the privilege of serving as the Law Librarian of Congress. Each year, we celebrate Constitution Day with a lecture, a panel discussion, or an interview by a distinguished legal scholar. Constitution Day, which is officially known as Constitution Day and Citizenship Day, is a federal commemoration observed each year to mark the signing of the U.S. Constitution on September 17, 1787, and to recognize all who, by coming of age or by naturalization, have become citizens. As President John F. Kennedy noted in his 1961 Constitution Day proclamation, it is a day for ceremonies set up to inspire all our citizens to keep the faith of our founding fathers and to carry out the ideals of United States citizenship. This year, in celebration, we are very pleased to welcome University at Buffalo's School of Law professor Samantha Barbas to provide a lecture about her book, Actual Malice, Civil Rights and Freedom of the Press in New York Times versus Sullivan. Samantha Barbas is a professor of law at the University at Buffalo School of Law, specializing in legal history, First Amendment law, and mass communications law. She holds a PhD in U.S. history from the University of California, Berkeley, and a JD from Stanford Law School. She is the author of 7 books, which have been featured in the New York Times Book Review, the New Yorker, the New York Review of Books, the Wall Street Journal, and on CNN. In 2020, she received a National Endowment for the Humanities Public Scholar Award for the subject of today's discussion, Actual Malice. I want to mention that you can type your questions for Professor Barbas in the Q&A box at the bottom of your screen, and she will answer questions for 10 minutes at the end of today's program. And with that, I will turn it over to Professor Barbas.
Well, thank you very much for that introduction and for inviting me to speak today. The First Amendment embodies a profound national commitment to, quote, uninhibited, robust, and wide open debate of public issues. Those timeless words about the meaning of freedom of speech come from New York Times versus Sullivan, a landmark decision issued by the U.S. Supreme Court in 1964, a decision that transformed the law of libel and freedom of speech, as well as the nation's experience of freedom of expression. New York Times versus Sullivan is widely regarded to be one of the great opinions of constitutional law and one of the most important First Amendment decisions of all time. It's a decision that's been tremendously important to politics, one that profoundly affects the workings of the press, and one that has shaped the contours of public discourse in the United States. It's a decision that continues to raise controversy, one that remains contested and in the news because of the broad protections it gives to freedom of speech, which some say has done so at the expense of other interests the law protects, such as reputation. What I'm going to do today is to tell the story of New York Times versus Sullivan, an improbable, serendipitous, and I think quite wonderful story. It's a story that I described in my book, Actual Malice, which was based on archival research into the case and the people behind it. What I wanted to do in the book was to tell a story of how free speech law was made in the 20th century and how the making of free speech law was intertwined with the civil rights movement. New York Times versus Sullivan is known to every law student as a case about the First Amendment, but it is also a civil rights story. The story that I tell in the book is a story of how the civil rights movement of the 1960s became the engine of constitutional change, not only in the area of the 14th Amendment, but also the First Amendment. It's a story of how the civil rights movement gave rise to modern free speech law and how the pursuit of civil rights and freedom of speech have been intertwined in our history. It's a story of how the American system of freedom of expression became exceptional, truly unique in the world in its broad protections for criticism, protest, and dissent. It's a story of how First Amendment law and constitutional law more generally is made not only from principle and precedent, but also from circumstance and from personalities. The law is made by people, by individual litigants and lawyers and judges and theorists who bring their traits and beliefs and experiences to the words that they write and the decisions that they make. So part of what I'll be doing is talking about the extraordinary people in New York Times versus Sullivan and how the landmark decision bears their unique influences. So I'll be discussing first how the Sullivan case came into being and how it grew out of the civil rights movement. Then I'll talk about how the Supreme Court decided Sullivan and why it decided the case as it did. And finally, I'll discuss Sullivan's enduring impacts on journalism, freedom of speech, and American culture more broadly, and why this 60-year-old Supreme Court decision still matters so much today. So I want to start by talking about the legal issues involved in the case. New York Times versus Sullivan dealt with libel. Libel is a civil cause of action that addresses injury to reputation caused by a false and defamatory or reputation-harming statement. Under the law of libel, someone who claims that they were defamed, that their reputation has been hurt by someone's false statement, could sue and potentially recover a monetary damage award. Under the rule of New York Times versus Sullivan, as a matter of First Amendment law, a public official suing for libel must prove that the defamatory statement was false and that the speaker made the statement knowing that it was false or with reckless disregard of whether it was false or not. This rule, known as the actual malice rule, provides broad protections for speakers. Sullivan transformed libel law and also First Amendment law. Libel law dates back to medieval England, but the story of New York Times versus Sullivan starts in the middle of the 20th century. There are many possible starting points to Sullivan. One is 1947, when civil rights activism was taking off in the South. The nation's social climate was becoming more favorable to civil rights. After the Second World War, the federal government was beginning to oppose segregation openly. Public opinion was turning in favor of civil rights, especially in light of recent experiences with fascism overseas. Segregation seemed to be increasingly at odds with the fundamental democratic values that the nation had fought for in the war. In 1947, the managing editor of the New York Times, Turner Catledge, made a historic decision, which was to put New York Times reporters full-time in the South. The New York Times was then, as it remains, the nation's newspaper of record, highly regarded for its credibility and its accuracy. The New York Times became the first national news outlet to have a Southern bureau. The purpose of this was to cover the burgeoning civil rights movement. The New York Times soon came to be regarded as the nation's most comprehensive source of news on civil rights. In 1954, when Brown versus Board of Education was decided, the Times was the only national news outlet covering the South. 2 years later, by the time of the Montgomery bus boycott, most of the major news outlets, including Time, Newsweek, and the television networks NBC, ABC, and CBS, had followed the Times and put journalists in the South. Segregationists reacted with hostility to this influx of reporters, which they likened to an invasion. They feared the power of the press to influence public opinion, and with good reason. The mass media were more influential than they had ever been. More Americans were reading the news than at any point in history. Television news was going straight into Americans' homes. Media coverage of civil rights protests and the violent backlash those protests generated would prove critically important in building national support for civil rights that would lead to the Civil Rights Act of 1964. The civil rights movement needed media coverage. It needed the New York Times, NBC, and CBS. Images of civil rights activists being attacked by police, and pictures of neatly dressed protesters being ejected from segregated lunch counters would illuminate for the world the cruelties of the South's racial system and the courage of those who defied it. By 1956, segregationists had embarked on a large-scale campaign to resist integration that was known as massive resistance. This included the passage of laws to forestall integration, outright violence against civil rights activists, and also attacking the press. Segregationists waged a fierce war on the national press in an attempt to intimidate it and to deter it from covering civil rights. Reporters who covered civil rights protests were beaten and assaulted. Cameras were smashed. Another weapon became libel suits. Segregationists realized that high-value libel lawsuits could be used to threaten and to terrorize and even to bankrupt media outlets that covered the civil rights movement. So I'll say something about libel law. Libel law was traditionally very strict. It was weighted in favor of the plaintiff, the person bringing the lawsuit. This reflected the high value that historically was placed on a person's reputation. We have always prized our reputations. A good reputation was often described as a person's most valued possession. As one legal treatise put it, an injury to reputation created far more pain and unhappiness than any physical injury could possibly occasion. One way that libel law was weighted in favor of the plaintiff was that it was judged under the rule of strict liability. This meant that a speaker or publisher could be liable regardless of their fault when they made the statement. So a statement that was false and defamatory and that the speaker made carelessly or even carefully could subject someone to liability. Before New York Times versus Sullivan, a person suing for libel didn't have to prove that the statement was false. The falsity of the statement was presumed under the law. The plaintiff didn't have to show any injury to their reputation, only that the statement had the potential to harm their reputation. So the only way that a speaker or publisher could defend a libel suit was to prove the truth of the statement completely and in all its particulars. This is difficult. Even if a statement was true, Proving its truth completely in a court of law was a daunting task. Libel laws impacted freedom of speech as a practical matter. A newspaper's decision to publish an article might depend on whether it had reason to believe it could be sued for libel. Yet, even though libel laws affected freedom of speech, the Supreme Court had said repeatedly before 1964 that libel law did not raise any First Amendment issues. False and defamatory statements were said to be unprotected by the First Amendment because they supposedly had no social value. Before 1964, there were no First Amendment protections in libel law. This meant that a newspaper that published criticism of a public official, one who was litigious and who wanted to retaliate, might find itself on the losing side of a libel suit if it published an innocent mistake or even a true statement if the publisher couldn't prove the truth of the statement completely. Now, this didn't mean that newspapers couldn't publish. Major newspapers like the Times found ways to prevent and to defeat libel claims. The Times used specialized attorneys. It conducted extensive fact-checking and vetting of text. The Times could publish somewhat freely by taking these precautions. Nevertheless, libel remained a formidable latent threat to the press, as the New York Times would discover. So another starting point of New York Times versus Sullivan was February 1960, when 4 college students sat in at the segregated Woolworth's lunch counter in Greensboro, North Carolina. This courageous act ignited a sit-in movement across the South that became the focal point of national attention and a catalyst of large-scale social change. The sit-ins soon reached Montgomery, Alabama, the state's capital, and a stronghold of Alabama's massive resistance. 35 students sat in at the segregated lunch counter at the Montgomery courthouse. These protesters, many of whom were students at the local Alabama State College, were attacked by mobs. 39-year-old Public Affairs Commissioner L.B. Sullivan, who supervised the police and who had run for office on a platform of complete segregation, permitted the mobs to attack the protesters while the police stood by and watched. Not long after this, the civil rights movement faced another crisis. This one involved Martin Luther King Jr., leader of the civil rights movement and head of the Southern Christian Leadership Conference, the SCLC. Founded in 1957, the SCLC focused on grassroots organizing and mass demonstrations as a way of drawing attention to civil rights and convincing Americans that federal legislation was needed to create the Second Reconstruction. Alabama authorities had brought King up on phony charges of tax evasion. Governor John Patterson had engineered these charges as a frame-up to remove King from the movement's leadership and to bankrupt the SCLC. Right after this, a group of civil rights activists in New York held a meeting in the apartment of singer and civil rights activist Harry Belafonte to brainstorm ways to raise money for the defense of the protesters and King. This committee, called the Committee to Defend Martin Luther King and the Struggle for Freedom in the South, planned fundraising rallies and concerts. It also planned to put an advertisement in the New York Times to solicit donations. A playwright named John Murray wrote up the text of the advertisement, which you see here. So this ad, which became the basis of New York Times versus Sullivan, was compelling and dramatic. It described, quote, an unprecedented wave of terror that had been visited on the protesters by, quote, Southern violators of the Constitution. It described how in South Carolina, when students went to segregated lunch counters, they were ejected, tear gassed, and soaked to the skin in freezing weather. It described how in Montgomery, protesters were expelled from school and how truckloads of police armed with shotguns and tear gas ringed the Alabama State College campus. This full-page ad ran in the New York Times on March 29, 1960. Its title was Heed Their Rising Voices. Listed at the bottom of the ad, along with a plea for donations, were the names of 64 eminent figures in the arts and politics who endorsed the ad, including Sammy Davis Jr., Marlon Brando, Frank Sinatra, and Eleanor Roosevelt. Also listed as endorsers were the names of 20 ministers who were leaders of the Southern Christian Leadership Conference. This ad had been written hastily, and it contained some errors about the events in Montgomery. For one, it said that protesters sang "My Country 'Tis of Thee" on the Capitol steps when they really sang the national anthem. The ad said that King had been arrested 7 times by Alabama authorities when he was only arrested 4 times. The most serious error was that the officials had padlocked the dining hall of the Alabama State College to starve and to punish the protesters, which wasn't true. The Times, which had been impressed with the eminence of the famous signatories, published the ad without checking its accuracy. This violated the Times' well-established policy of checking all texts that appeared in the newspaper, including advertisements. And what happened next was sheer serendipity. Only 394 copies of the Times were circulated in Alabama. One of them happened to go to the local newspaper, the Montgomery Advertiser. Editor Grover Hall had a long-standing grudge against the Times and the Northern press for criticizing segregation and purportedly casting aspersions on the South. When Hall saw the ad and saw that there were errors in it, he recognized a brilliant opportunity to sue the New York Times for libel. Under well-established libel law, the Times, as the publisher of the ad, was just as responsible for the ad as the advertisement's creators. Hall and a local attorney, a 37-year-old Harvard graduate named Roland Nachman, encouraged 3 Montgomery officials, including L.B. Sullivan, to sue the Times and 4 leaders of the Southern Christian Leadership Conference, ministers whose names were put on the ad as endorsers and who were Alabama residents. Importantly, these civil rights leaders hadn't consented to having their names on the ad. They didn't even know that their names were on the ad. Their names had been put on the ad at the last minute without their consent by the Committee to Defend Martin Luther King. The Alabama officials said that the ad had defamed them insofar as it accused them of being complicit in brutality against the protesters. None of the officials were actually mentioned by name in the ad, which referred generally to the police and to authorities. Moreover, it's unlikely that their reputations were actually harmed. Being known for committing or abetting violence against civil rights protesters would have enhanced the reputations of authorities in Montgomery at the time. Yet, under existing libel laws, all the plaintiff had to demonstrate was that the statements had the potential to injure his reputation and that they referred to him. The statements were presumed to be false. The Times and the ministers couldn't use the defense of truth because there were errors. Here, the officials believed was a wonderful chance to use libel law to destroy the Times and the Southern Christian Leadership Conference. The statements in the ad were true in their overall meaning. The officials had been complicit in violence against the protesters, although perhaps not all the specific acts they were accused of. Sullivan and 3 other Montgomery officials each sued the Times and the 4 civil rights leaders for $500,000. Governor Patterson then sued the Times and the 4 civil rights leaders and Martin Luther King for $1 million for purportedly being defamed by the ad. The Times and the civil rights leaders faced $3 million in damages in 5 libel suits brought over the Heed Their Rising Voices ad. 7 officials in Birmingham, including the notorious Bull Connor, then sued the Times for over $3 million over the Times' truthful reporting on official violence against civil rights activists in that city. These lawsuits were clearly being used to punish the Times for its civil rights reporting and its pro-integration stance, and to stifle that reporting by intimidating and burdening the newspaper. They were also meant to quash the SCLC and to inform the civil rights movement that it would be persecuted if it continued to challenge the status quo. The Alabama officials intended to let the Times and the entire Northern press know that they faced devastating libel suits if they covered civil rights, supported integration, ran King's advertisements, or published any criticism of Alabama. As a result of the libel suits, the Times faced the possibility of bankruptcy. Never before in American history had there been a coordinated official conspiracy of this magnitude to use libel law to undermine and destroy a disfavored newspaper and social movement. In a historic move, the Times took its reporters out of Alabama to avoid further libel trouble. As a result, the Times had no journalists on the ground in Alabama, one of the most important sites of civil rights activity during crucial years of the civil rights movement. Other newspapers contemplated taking their reporters out of Alabama for fear of being sued. The libel suits were having a chilling effect on the press. Sullivan's libel suit, the first to go to trial, was heard in November 1960 before an all-white jury in the segregated courtroom of Judge Walter Burgwin Jones. On the day of the trial, a celebration of the 100th anniversary of the Confederacy was taking place in Montgomery. Judge Jones permitted local residents to attend the trial dressed in Confederate uniforms. Since the Times admitted that parts of the ad were false, Sullivan's lawyers needed only to show that readers would think of Sullivan as head of the police when they read about the police in the advertisement. Not surprisingly, the all-white jury awarded Sullivan $500,000. This was the largest libel verdict in the country to that time. Shortly after, the mayor of Montgomery, whose trial was also held in Jones's courtroom, won $500,000 against the Times and the ministers. Noted the Chicago Tribune, even the most intrepid publisher must be intimidated into silence. These victories spurred copycat lawsuits. Officials in the South got on the bandwagon and filed libel suits against the media over their civil rights coverage. By 1964, officials had brought 17 libel suits against media outlets, seeking damage awards of more than $288 million. The Southern Christian Leadership Conference was hemorrhaging money in the libel suits. The SCLC couldn't progress in its projects, including freedom rides and sit-ins, if its leaders were saddled with multi-million-dollar libel judgments and defensive litigation battles. The officials had sued the most prominent leaders of the civil rights movement. Ralph Abernathy was pastor of Montgomery's First Baptist Church, a co-founder of the SCLC and a leader of the Montgomery bus boycott. Solomon C. had been involved in grassroots civil rights activities in Montgomery since the 1930s. Joseph Lowry, a pastor in Alabama, was a co-founder of the SCLC and helped lead the Montgomery bus boycott. Fred Shuttlesworth, the outspoken pastor of the Bethel Baptist Church in Birmingham, and also a founder of the SCLC, had been beaten by mobs and imprisoned for his efforts to desegregate Birmingham. He held the record as the most jailed civil rights leader. In one of the cruelest episodes in this story, Alabama authorities seized the minister's property to pay the libel judgments. They hauled away Lowry's old Chrysler and Shuttlesworth's 1957 Plymouth. They auctioned Abernathy's interest in farmland that his family had worked for generations. King described the libel cases as a civil rights crisis. The libel suits, he said, had become a new and potent weapon in the arsenal of the segregationists. Predictably, the Times and the ministers lost their appeal to the Alabama Supreme Court. The ministers decided to appeal their case to the U.S. Supreme Court on the grounds that the trial in the segregated courtroom and the libel suits themselves were motivated by racial animus. But the Times wasn't convinced that it should appeal, knowing it was unlikely to succeed. The law wasn't on their side. The Warren Court, which would later be known as a free speech court, wasn't yet a reliable guardian of freedom of speech. The Supreme Court under Earl Warren, who had been Chief Justice since 1953, was known for its bold program of constitutional reform that had transformed the lives of ordinary Americans in ways that no previous Supreme Court had ever done. Expanding its conventional jurisdiction, the court had reached out to decide important social issues such as civil rights, privacy, due process, and censorship. For the first time, the court established itself as a forum for the resolution of social problems, an institution that would boldly implement social change. The Warren Court was an advocate and defender of civil rights, having transformed deeply rooted patterns of segregation and discrimination. Yet, before New York Times versus Sullivan, the Warren Court did not have a systematic First Amendment jurisprudence. Clear and present danger rule, which held that speakers could not be punished unless their speech posed a clear and present or imminent threat of substantial harm, had been adopted by the Supreme Court in the 1930s and had led to decisions that could be characterized as civil libertarian. But that trend was undercut by decisions during the Red Scare of the 1950s that had upheld the government's persecution of purported communists. The New York Times had a policy of not settling libel cases. It did not want a reputation for being an easy target for libel suits. but the Times was tempted to settle L.B. Sullivan's case. The Times lawyer was a tweedy and proper gentleman named Louis Loeb. Like most lawyers, Loeb did not want to subject his client to undue risk. It was Loeb who had made the decision to take the Times reporters out of Alabama. Yet Loeb saw the long-term risks if the Times didn't appeal. If the Times settled, who else would come along and sue the newspaper for millions, he wondered. Would the segregationists in the next round of libel suits sue the New York Times out of existence? If Sullivan's verdict were sustained, he believed the media might be forever restrained in its reporting on civil rights. Loeb told the Times executives that the future of the newspaper and journalism were on the line, and that they had to take a chance and appeal to the Supreme Court on the grounds that libel laws like Alabama's, which was similar to many states' libel laws at the time, impaired freedom of speech and press. The Times leaders weren't convinced, but they gave Loeb permission to consult a constitutional law expert. Loeb called up an old acquaintance, Herbert Wexler of Columbia Law School. This was perhaps one of the most important phone calls in the history of journalism. 52-year-old Wexler was one of the most esteemed legal academics in the country. He had argued a dozen cases before the Supreme Court, had served in the Department of Justice, and had written influential law review articles. Wexler was known for his formidable personality and his intimidating intellect. A colleague once described Wexler's ability to cut the heart out of an argument before the speaker even realized that they had more than a flesh wound. Wexler convinced the newspaper's leaders that they should appeal. He explained to them how First Amendment law was evolving. The court in previous decades had taken areas of speech that were once considered to be unprotected, such as pornography and contempt, and put them under the First Amendment's protections. He believed there was a chance that the court would do the same with libel. The Times leaders consented, and Wexler became the lead attorney on the case. The Times was betting it all on Wexler. Of course, this was a good bet. Yet what lay ahead, even for someone of Wexler's stature, was truly daunting. How would Wexler convince the Supreme Court that libel raised a First Amendment issue when the court had said repeatedly that it did not? Wexler came up with a brilliant strategy, which was to shift the main issue in the case from the right to protect individual reputation to the right of citizens to criticize government and its officials. Wexler argued that Alabama's libel law, which permitted a public official to win a damage award against someone who criticized the conduct of an agency that the official supervised, unless the jury found the statement to be entirely true, he said this was akin to the crime of seditious libel, the long-defunct crime of criticizing the government. In his petition to the court, Wexler reached back into history and made an analogy between modern libel law and the old law of seditious libel, both of which impaired the ability of citizens to criticize government and its officials. In medieval England, statements that threatened to diminish respect for the government or its officials were punishable by fines, imprisonment, and even the pillory. The crime of seditious libel was transplanted to colonial America and used against critics of local representatives of the crown. It was highly unpopular, and many complained that the law punished legitimate criticism of government. In 1798, a Sedition Act was passed that made seditious writing that was critical of Congress or the president, a crime. James Madison and Thomas Jefferson argued that the Sedition Act was unconstitutional and tried to raise opposition to it in the state legislatures. Madison drafted, and the Virginia legislature approved, resolutions arguing that freedom of speech and press were essential to safeguard a Republican political system. The Sedition Act violated the First Amendment because it was leveled against the right of freely examining public characters and measures. That is the only effectual guardian of every other right, Madison had written. The Constitution created a form of government under which the people, not the government, possess the absolute sovereignty. The Sedition Act expired in 1801, and the crime of seditious libel fell into oblivion. Although the Supreme Court never ruled on it, it was assumed that seditious libel was unconstitutional. 20th century opinions by Justices Oliver Wendell Holmes and Louis Brandeis had suggested as much. As Brandeis stated famously in his concurring opinion in Whitney versus California from 1927, freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth. Public discussion is a political duty, and this should be a fundamental principle of the American government. Wexler argued that the Times advertisement was as much a political document as those punished under the Sedition Act, and that Alabama's libel law could not be reconciled with the court's rulings on the scope of freedom of the press safeguarded by the Constitution. Wexler said that those rulings started with the assumption that one of the main objectives of the First Amendment was to protect the right to criticize all public institutions. Alabama's libel law did not survive that test because it stifled criticism of official conduct no less potently than seditious libel. Brilliantly, Wexler had taken a libel case and turned it into an opportunity for grand theorizing about the meaning of the First Amendment. Wexler made the sweeping argument that there is an unconditional right to criticize government and its officials, that criticism of public officials was protected entirely by the First Amendment, even if it was intentionally false and defamatory. Knowing that this bold argument wasn't likely to win, Wexler offered other reasons why Sullivan's judgment was unconstitutional. The ad didn't mention Sullivan by name. There was no injury to Sullivan's reputation. In passing, Wexler proposed a version of what became the rule of Sullivan, the actual Malice rule. In 1963, the Supreme Court voted to hear Sullivan's case, New York Times versus Sullivan, and the minister's case, Abernathy versus Sullivan. It isn't difficult to figure out why the court took these cases. The libel attack on the press and the civil rights movement represented another example of Southern intransigence and resistance to the court's integration mandates. The justices were all aware of the slew of libel cases coming up from the South and their chilling effect on coverage of the civil rights movement. The justices considered the petitions of the Times and the ministers as newspapers and television screens featured images of protesters, including young children, being blasted by fire hoses and attacked by police dogs in Birmingham. The court engaged with the cases out of concern for the civil rights movement. But the justices were also interested in the free speech issues at stake. The relationship between libel and the First Amendment was an important issue that the court hadn't addressed to that point. The oral arguments were scheduled for January 8th and 9th, 1964. It was an important term at the Supreme Court. Cases involving desegregation, school prayer, reapportionment, and obscenity were being argued at practically the same time as Sullivan. Roland Nachman flew from Montgomery to Washington to argue the case. He told Sullivan that he was certain he would have a, quote, bomb-proof victory, as he put it. He said, either we will win or they, meaning the Supreme Court, will change the law of the land. Of course, that's exactly what happened. The austere and orderly setting of the U.S. Supreme Court was a far cry from the violence-laden streets of Birmingham and Judge Jones's courtroom in Montgomery. None of the sectional conflict and racial animus that had brought forth the case were apparent when the 9 justices proceeded through the red velvet curtains into the ornate marble-walled courtroom and sat down in their high-backed chairs behind the mahogany bench. A distinguished group of spectators came to hear the oral arguments, including King, whose presence was noted by everyone and heightened the importance of the proceedings. Wexler made his argument for absolute protection for criticism of public officials. He told the justices, I believe that if James Madison were alive today, the submission I am making is the submission he would make. Nachman presented the case as an ordinary libel case that had been tried under well-established rules. The minister's lawyers told the justices that the central fact of this case is that the ministers are being punished because they had the courage to speak out in the struggle to achieve rights guaranteed by the Constitution for all citizens, regardless of race or color. The justices met at their weekly conference to discuss the cases. All of them were clear that Sullivan's judgment had to be reversed, but the grounds for reversal were a matter of debate. Hugo Black and William Douglas, who believed that the First Amendment protected speech absolutely, supported Wexler's broad argument. But the other justices weren't willing to go that far. They believed that there should be protections for reputation and that the right of reputation should be balanced against freedom of speech. But how to strike that balance was unclear. Warren asked Justice William Brennan to write the opinion. Warren often turned to Brennan to draft opinions in high-profile cases in which the justices were clear about the result that they wanted to achieve, but didn't agree on how to get there. Warren relied on Brennan for this task because he knew that Brennan, with his genial and gregarious personality, was a remarkable negotiator and unifier with an ability to draft opinions that would secure the 5 votes needed for a majority. Warren also knew that Brennan shared his commitment to civil liberties and civil rights. 56-year-old Brennan was not only one of the most important intellectual influences on the Warren Court, but one of history's most influential justices with a profound impact on public policy. Brennan had been considered a moderate when he was appointed to the U.S. Supreme Court from the New Jersey Supreme Court in 1956. But it wasn't long into his tenure on the court that he embraced the liberal worldview that defined his legacy as a justice. Brennan's rulings advocated personal rights and freedoms, and they reflected a tenacious commitment to advancing the Constitution's promises of fairness and equality. By 1964, Brennan was arguably the most important justice on civil rights. He was also a leading justice on the First Amendment, having written 7 majority opinions in free expression cases. Brennan worked on the Sullivan opinion between January and March 1964. Brennan and his clerks produced the opinion under time pressure. There were many cases competing for Brennan's attention, and Brennan was aware that the Alabama situation required a swift resolution, given the drain on the resources of the Times and the SCLC, the progression of civil rights events calling out for media coverage, and the rest of the Alabama cases coming up through the courts. Brennan wrote 8 drafts of the opinion in which he developed the main rule of the case, actual malice. Actual malice is a legal term of art that is a little misleading. Brennan regretted that he chose the term because it suggests spite or ill will, what we commonly think of when we hear malice. But under the actual malice rule, a public official can recover damages for libel only if the official can show that the defamatory statement was made with knowledge that the statement was false or reckless disregard of whether it was false or not, which means that the speaker had strong reason to believe the statement was untrue and went ahead and made it anyway. This sweeping rule was used to strike down the judgment against the Times and the ministers. Brennan created the actual malice rule to address the extreme and unusual facts of the case. He knew that a negligence standard of carelessness, the usual fault standard in personal injury cases, which would have been the obvious standard to apply, wouldn't have protected the Times, since it admitted that it had been careless in publishing the ad without checking the facts. Brennan, the consummate negotiator, also created actual malice as a compromise to please the justices who would have taken Wexler's extreme position and those who preferred balancing approaches to the First Amendment. Brennan also saw another reason for adopting actual malice. Even a negligence or carelessness standard, he believed, wouldn't provide speakers with the latitude that they needed to make statements that were critical of public officials. Here, Brennan drew on the concept of the chilling effect that he had created in earlier opinions. He had used this term to describe laws that inhibited freedom of speech by generating self-censorship. Presented with rules that were overly strict, speakers would restrain themselves and only make statements which steer wide of the unlawful zone, as Brennan put it. Freedom of speech, Brennan had written, needed breathing room to survive. On March 9th, 1964, Brennan announced the unanimous opinion reversing Sullivan's judgment. He said, "We hold that the rule of law applied by the Alabama courts is constitutionally deficient for failure to provide the safeguards for freedom of speech and of the press that are required by the First and 14th Amendments in a libel action brought by a public official against critics of his official conduct." The urgent situation in Alabama had called on the court to take a fresh look at an entire area of law and to re-examine the principles and values of the First Amendment. The opinion went on to announce the actual malice rule. With it, the court radically shifted the balance between the protection of free speech and the protection of reputation. The actual malice rule did not eliminate the law of libel, but it created a substantial hurdle for public officials to overcome. Brennan wrote into the opinion his concepts of breathing room and the chilling effect, libel law's rules of strict liability, and the requirement that the defendant prove the truth had a chilling effect by producing self-censorship, Brennan wrote. It was thus inconsistent with the First Amendment. Brennan recognized that under the actual malice rule, harms caused by some false statements that were not made with reckless disregard of the truth, would go unremedied. But this was the price of freedom of expression, he wrote. Erroneous statement is inevitable in free debate, and it must be protected if the freedoms of expression are to have the breathing space that they need to survive. This was one of the most controversial parts of the opinion. As one scholar put it, Sullivan protected falsity to protect the truth. But even more important and far-reaching was Brennan's vision of the First Amendment. Brennan announced for the first time a central meaning of the First Amendment: the freedom to criticize government and its officials. This freedom was part of what Brennan described as America's profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. There is a profound national commitment to uninhibited, robust, and wide open debate of public issues. Such debate, Brennan wrote, may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. It was the most forceful and extensive articulation of the role of freedom of speech in democracy, and it transformed First Amendment law and theory and the nation's experience with freedom of expression. The Supreme Court saved the nation's newspaper of record from ruin. The Sullivan decision not only reversed L.B. Sullivan's judgment, but turned back the segregationists' libel attack. It freed the press to report fully and freely on the civil rights movement, coverage that could have been undermined if the next wave of libel suits had gone through the courts without Sullivan's protections. Post-Sullivan media coverage of the civil rights movement was indeed robust and wide open. Reporting on protests in Selma, Alabama the following year helped to facilitate the national consensus on civil rights that led to the Voting Rights Act of 1965. Insofar as the success of the civil rights movement can be attributed to direct action protests and media coverage of those protests, Sullivan was one of the most important Supreme Court decisions facilitating the advance of the civil rights movement. New York Times versus Sullivan freed the Southern Christian Leadership Conference from the burden of defending the libel suits. King issued a statement describing the decision as an affirmation of the fact that forces of ill will can no longer silence voices speaking for freedom. Sullivan was issued on Ralph Abernathy's birthday. "It's the best birthday present I've ever received," he said. "Next year, I hope the gift will be freedom." The concepts of breathing space and the chilling effect became central to First Amendment doctrine. The phrase uninhibited, robust, and wide open has been quoted in more than 60 Supreme Court opinions to justify the protection of speech in a variety of areas, such as public employee speech, labor picketing, and campaign finance. With its declaration that freedom of speech is fundamental to democracy, Sullivan became the foundation of modern First Amendment law. Brennan's language became important not only to legal doctrine, but also to our free speech tradition, the way that Americans have come to understand the meaning of freedom of speech. Political theorist Alexander Meiklejohn called Sullivan an occasion for dancing in the streets. But not everyone was dancing in the streets. Sullivan was contested in 1964, and it remains contested for the broad protections it gives to speakers, including the press. Now, Sullivan does not protect only the press, it protects all speakers, although the press has historically been the most frequent defendant in libel cases. Sullivan led to a sea change in press practices. It enabled the press to take on reporting on public affairs without fear of devastating libel suits. Of course, the press still gets sued, but it's less likely to lose. And the kind of large-scale libel attack that we saw in Alabama in the 1960s was no longer possible under Sullivan. New York Times versus Sullivan facilitated investigative reporting. Disclosures about the Vietnam War and Watergate might have remained hidden if the press lacked the shield of Sullivan. However, some allege that Sullivan led to irresponsibility in journalism. They attribute the rise of tabloids and gossip in the media, for example, to the actual Malice rule. Some have attributed the spread of misinformation to Sullivan. They allege that the constitutional law of libel doesn't incentivize the production and dissemination of the truth. Some have said that the court didn't give enough weight to the interest in reputation. Some say that the court might have struck a different balance between the protection of free speech and the protection of reputation if Sullivan's case hadn't involved such extreme and dramatic facts. This criticism that the constitutional law of libel fails to give enough protection to reputation became even stronger when the Supreme Court, starting in 1967, began to apply the actual Malice rule to libel cases involving public figures, category of individuals that the court has defined broadly as a person who is not an elected official, but who gets involved in public life, even in a relatively minor way. As it stands, the actual Malice rule applies to a broad range of libel plaintiffs. Some have argued that this public figure doctrine has no relationship to the central meaning of the First Amendment established in Sullivan, the right to criticize public officials. This is one reason why the constitutional law of libel remains contested. Others argue that our social landscape and media landscape have changed dramatically, especially with the internet and social media, and how easy it is to defame people online. Critics of the Sullivan regime argue that reputation has become fragile and that practically anyone can become a public figure in libel law just by commenting on social media, and that libel law should be adjusted to reflect these realities. They argue that democracy requires not only freedom of speech, but also the protection of civility and interpersonal respect, and that limitations on some kinds of speech may enhance democracy more than hinder it. New York Times versus Sullivan has been memorialized as a case about the First Amendment. The civil rights dimension of the case tends to be obscured in most discussions of Sullivan. I think this has to do in part with the fact that there are almost no mentions of civil rights in the Sullivan opinion. Wexler in his brief and Brennan in the opinion barely mentioned the civil rights movement because they wanted to achieve a broad ruling that would protect freedom of speech beyond the civil rights context. The media covered Sullivan as a freedom of the press case and not as a civil rights case. Yet no one reading the headlines in 1964 could have ignored Sullivan's relationship to the civil rights movement. Sullivan was the product of marches in the streets in Birmingham. It was the consequence of beaten and bloodied freedom riders and Bull Connor's attacks. It was the result of the slew of libel cases coming from the South and the threat that they posed to the press. It was the vindication of a growing public consensus in favor of civil rights, which the court's ruling reflected and reinforced. Sullivan was one of several cases in which the Warren Court strengthened the First Amendment to protect the civil rights movement. Through cases like Sullivan and NAACP versus Alabama from 1958, in which the court protected the NAACP's right to assemble and to conduct civil rights litigation, the civil rights movement was a major force behind the expansion of First Amendment law. The Warren Court knew that civil rights could not be achieved without robust protections for freedom of speech, assembly, and association. With the First Amendment decisions that emerged from the civil rights era, the court began the process of overturning precedents that had given the government a free hand to destroy radical groups in the Red Scare. Through First Amendment cases involving the civil rights movement, the court began forging a body of free speech law that was strongly protective not only of civil rights activists, but all dissenters, from anti-war protesters to hate groups like the Westboro Baptist Church. Our public discourse since 1964 has indeed been free, uninhibited, robust, and wide open. The American system of freedom of expression is truly exceptional. There are few restraints on criticism of government. We are largely free to express our views, even if some may find those views repugnant. We are free to protest, to demonstrate, and to question. Our expansive speech freedoms are unique in the world. New York Times versus Sullivan had much to do with that. The law and culture of freedom of expression that Sullivan helped bring about has brought with it tremendous benefits and also many challenges. I hope to have shown how this landmark decision played a critical role in shaping free speech law, journalism, and American society more generally since 1964. The story of Sullivan illustrates how constitutional law develops from the intersection of facts in real-life situations, sometimes unique situations, with broader social issues and concerns. In this case, events and conflicts growing out of the civil rights movement produced far-reaching changes to an established area of law and yielded, through the work of brilliant legal minds, one of the most important articulations of the meaning of free speech in American history. That articulation was perfectly tailored to its times, yet it continues to have enduring vitality and significance. Thank you very much.
Thank you, Professor Barbas. That was truly captivating overview of this landmark case with such remarkable clarity on the facts, the legal issues, the impact, and the general atmosphere surrounding this revolutionary time in the nation's history and its relationship to the civil rights movement. So that was wonderful. Thank you. It is time now to address questions from our audience. And I just want to remind our audience that you can type your questions for Professor Barbas in the Q&A box at the bottom of your screen. And I see we have a few in the queue. So the first question is, did Brennan have a role in convincing the court in the 1954 Brown decision?
Unfortunately, actually, I think Brennan was not on the Supreme Court at that time. So, but that area of law and that case is beyond the purview of this particular study.
Great. Do you think there is a substantial possibility that the court might reconsider Sullivan? And if it does, do you think it would survive if the court adopted an originalist methodology?
Yes, so there has been so much discussion in the past half decade about the possibility of, the Supreme Court overruling New York Times versus Sullivan and what that might mean. And as I see it, that possibility is very unlikely. There is no justice on the current Supreme Court who has expressed a desire to overrule New York Times versus Sullivan, with the exception of Clarence Thomas. And he has suggested that, in his view, the actual malice standard does not comport with his originalist view of the law. So he alleges that there is nothing in the text or the history of the Constitution that would support this kind of sweeping protection for speakers in libel law. The argument is that, at the time of the framing of the First Amendment, the law of libel was very robust. The framers of the First Amendment had no intention that the First Amendment would intrude on any aspect of the state common law, and that therefore this constitutionalization of libel law simply cannot be justified. So that is one argument. I think that if the Supreme Court were to alter any aspect of the constitutional law of libel, it would not be in the form of overruling Sullivan itself, which deals with public official libel cases, but rather with these extension cases I mentioned, cases in which the court extended the actual malice doctrine to libel cases involving public figures. And there has been some suggestion that perhaps the standard there should be changed to negligence to make it easier to recover for reputation, or that maybe the definition of who is a public figure should be reconsidered. But that's a question we've been hearing a lot about lately. What's going to happen to Sullivan in this day and age? And I feel fairly confident that Sullivan itself is safe.
You touched on this next question a little bit, but I'll read it anyway in case you want to add anything more. The question is, what challenges to Sullivan do you see with the current SCOTUS, and Sullivan now noting this court will not hesitate to overturn stare decisis?
Yeah, so as I suggested, I think that New York Times versus Sullivan, which is, canonical, right? A landmark decision that is truly the foundation of our system of freedom of expression, will not be altered. But these cases, again, in which the court extended the actual malice doctrine to libel cases involving public figures, there's been a lot of criticism of this doctrine, especially in our age of the internet and social media, when you could potentially become a public figure for the purposes of libel law just by commenting on something on Twitter, right? By involving yourself in a public issue through writing something online. And there are some who have said that this, takes reputational protection away from too many people in an era when it's very easy to become a public person. And Justice Gorsuch actually expressed a sentiment similar to that in a dissenting opinion, in which from a couple of years ago, in which the court decided not to take a case in which they would have reconsidered the public figure doctrine. But I think that was the argument that we need to reconsider Sullivan in a time when the communication landscape is so different from what it was in 1964 when the case was decided.
We have several other great questions. Let's see. The desire to provide appropriate breathing space for speech seems to have been an important consideration in the court's recent decision in Counterman versus Colorado to add a mens rea element of recklessness to true threats cases. Are there other recent cases where this current court has built on the legacy of Sullivan to expand First Amendment law?
Yes, that's a very important question. Unfortunately, I'm not that familiar with some of the more recent cases in which the court may have drawn on the Sullivan concept of breathing room to maintain or expand protections for freedom of speech.
Great, thank you. this one is a speculation question. Please speculate on how today's court would rule on Sullivan issues.
Yeah, so again, I think that there is not a lot of support on the current Supreme Court, to alter the constitutional law of libel, which again, would represent sort of a massive alteration to the system of freedom of expression as we know it. And although I think there are many, right now who are trying to, get a case before the Supreme Court that would invite it, to reconsider the Sullivan doctrine, constitutional law of libel. But again, I'm not, certain that is something that is likely to happen.
Let's see. If any, what personal suggestions would you advise regarding the Malice rule?
I think the Supreme Court in Sullivan struck a very wise and appropriate balance between the protection of free speech and the protection of reputation. Notably, the court did not accept Wexler's broad argument, right? It did not eliminate the law of libel as regards public officials. It did not write into law this absolute protection that Wexler was arguing for. So it is possible for a public official, a public figure who has been defamed and who can demonstrate reckless disregard of the truth to recover damages for injury to their reputation. At the same time, of course, the actual malice standard provides broad protections for speakers. So I think that, the court struck a very appropriate compromise, and one that has served us well over the past 60 years, one that has allowed the press to do a lot of important reporting on critical affairs, and that has given us all, the breathing space to have important conversations about issues that matter.
Well, thank you so much. In light of the, let me make sure. We've addressed, I see some other questions. Let's see. Okay, this will be our last one. You mentioned that the US has the broadest protection of free speech in the world. Can you comment on how other countries and institutions view freedom of the press and speech, such as the UK, France, the EU Court of Human Rights, or anywhere else?
Yes, so that is a very important and very broad question that I probably could not begin to address in the short time here. But I will say that, there is no other country in the world that has something like a Sullivan rule. And I think, in rejecting the actual malice standard, some other countries have suggested that perhaps, reputation is a value of, great importance, perhaps more importance, but also that there had really been no kind of extreme set of circumstances in those countries that had given rise to this necessity to protect the press, like we had, with the civil rights movement in the South in the 1960s. So it's a very interesting question. You think about why our system of free expression is so expansive. And I make the argument in the book that historical circumstance has something to do with that.
Well, wonderful. Thank you so very much. And I can't think of a better way to end today's program with an overview of a signature resource from the Library of Congress, Constitution Annotated. And joining us is our colleague, Jean Dennis, who is the Senior Counsel for Legal Programs and Initiatives in the American Law Division of the Congressional Research Service. Jean, I will turn over the virtual floor and the closing to you.
Well, thank you, Aslihan. Just a second, I will share my screen. We can share with everyone the Constitution Annotated. So hopefully, if you cannot see the screen, somebody will let me know.
Oh, it's on. We can see it. Thank you.
Perfect. Okay. Well, first of all, I want to thank the Law Library for sponsoring the Constitution Day program, and also Samantha for bringing with us this excellent discussion of the Sullivan decision. I think that was a fantastic way to celebrate Constitution Day. To wrap up the day's events, I'd like to share with you the library's online Constitution Annotated, constitution.congress.gov, which is celebrating its 4th anniversary today. For those of you not familiar with the Constitution Annotated, this Senate document has served as Congress's official record of the Constitution for over 100 years. It provides Congress and the public an explanation of every provision of the Constitution and how the Supreme Court's interpretations of those provisions have evolved. The online Constitution Annotated is the latest iteration of a project Congress began in 1795, when it enacted legislation to provide members with personal copies of the Constitution to facilitate the legislative process. By the 1830s, these copies were being indexed to enable members to find relevant provisions more easily. By the 1870s, the copies included lists of Supreme Court decisions interpreting each provision. In 1921, Congress passed legislation to provide for each constitutional provision to be annotated with explanations of relevant Supreme Court decisions. And that's the Constitution Annotated that we have today. 2019 saw a further evolution of the Constitution Annotated when the library launched constitution.congress.gov, the web version of the Constitution Annotated. Since its launch, constitution.congress.gov has had more than 22 million visits and more than 44 million page views. Written by attorneys in CRS's American Law Division, the Constitution Annotated conforms to CRS's standards of objective, authoritative, timely, and nonpartisan analysis that informs CRS's advice to Congress. The online Constitution Annotated is designed to make locating information on the Constitution easy. Most people access the content by either conducting a keyword search or navigating the browse page. Because the website's key feature is searchability, there's a global search bar spanning the header of every page. No matter where you are, you can easily conduct searches. Search results take you to the relevant essay with the search terms highlighted. Here we have the exclusionary rule. At the top of each essay page is a clickable breadcrumb that traces the essay back to its place in the Constitution. Cases discussed in the essays are linked so that users can easily read the primary document. As an alternative to using keyword searches, users can use the Browse page to search for relevant information on the Constitution. The Browse landing page outlines the Constitution Annotated and mirrors the structure of the U.S. Constitution. This is particularly helpful to users who may have a more limited background on the Constitution. The Browse page can be expanded to provide greater detail on potential topics of interest. Essays are organized in section and clause groupings and then into subgroups that address specific topics. The online Constitution Annotated includes additional material on the Constitution, including reports written by CRS attorneys and other library resources on the Constitution. For any questions regarding the online Constitution Annotated or constitutional research, please contact our very own law library. And for the final thing, please celebrate Constitution Day by exploring the Constitution Annotated and sharing it with your friends and colleagues. Thank you for joining us today to celebrate the Constitution.